Good evening. Happy Thursday. So, this is the Decastro versus Abrams case. The judge issued an order. Plaintiff's motion for leave to file a second amended complaint pursuant to Rule 15D of the Federal Rules of Civil Procedure, ECF number 101, is granted. Now, I don't like the language here because remember, FRCP Rule 15D is the supplemental complaint. It's a supplemental pleading. But the court is saying that it's granted leave to file a second amended complaint. Now, if you remember, the court previously called another document the second amended complaint. Let's just back this bad boy up. So plaintiff's motion to file a second amended complaint is granted. So this is the second time the court has used second amended complaint. And this time it says a second amended complaint pursuant to Rule 15D. And I don't know what the court's trying to say there. I honestly don't. I've thought about it. I have mused upon it. And my best guess would be that the court is telling Chile to actually redraft his entire complaint. That is my best guess. And I will tell you why, because it goes on. Defendants' motions to dismiss, ECFs number 94 and 95, shall remain pending, and defendants need not refile their motions unless ordered to do so by the court. And what that sentence is telling me is that as it stands, where we are, if Chile does nothing or the wrong thing, the court is going to grant the motions to dismiss. That's what I'm seeing right there. Basically, the court is saying to the attorneys, you've already won. You don't need to do anything else unless Chile actually manages to somehow fix things or address some of the issues that you raised. Court goes on, defendants may nonetheless supplement their motions to respond to any new allegations included in plaintiff's second amended complaint if they believe the legal arguments need to be supplemented in response to the new complaint. i.e., if Chile manages to pull his head out of his ass and actually plead causes of action that will survive a 12b6 or could potentially survive a 12b6, then the defendants get to supplement, but only if they need to, and they probably won't. Plaintiff is advised that any further motions for leave to amend his complaint will be subject to a more exacting scrutiny, i.e., Chile, you don't have unlimited bites at the apple. You don't have unlimited times up at bat. You are getting close to striking out. So you need to quit fucking up. Your half-ass motions, your misunderstandings of the law, of legal procedure, of what words mean, needs to be addressed. Plaintiff, using the electronic case filing system, should now file the document for which leave has been granted in accordance with the CMECF administrative procedures. Plaintiff must include leave to file granted on date of order in the caption of the document. So he gets another shot. I strongly suspected he would get another shot. I believe I called that. And my best guess is that the court is basically giving him a heads up that he really needs to amend his complaint because it's not going to survive. Now, the supplemental pleading might survive, but he needs to amend his complaint. That's my best guess. Now, I check I check Decastro versus Wagner every so often, and I did notice something. Well, first of all, let's go back to Decastro versus Abrams. In Decastro versus Abrams, you'll see that there are oppositions to motions. So when you go into the ECF filing system, you get oppositions to motions. And I will be perfectly blunt with you. I have never gone into the CMECF filing system. We have, and I'm not being sexist here, we have gals who do that. I'm sure we could hire men to do it, but currently we only have gals doing it. And so there you go. So I don't know if that's something that you name. I don't know how it works. So here in the, I know in the Ninth Circuit, when I look at stuff like this, I see opposition. And here in the First Circuit, we're seeing oppositions. However, if you look at Decastro versus Wagner, this is Sixth Circuit, I believe. You see response and opposition. And response and opposition. That's what attorneys filed. So that might be a circuit thing. That might be an Ohio thing. I don't know exactly why they do that. There are differences in different jurisdictions, and so my understanding from California and from the Ninth Circuit might be completely different than what somebody in Ohio in the Sixth Circuit would be experiencing, or would be the language that they would be using. So, like, there's voir dire and voir dire and voir dire. I mean, there's a whole bunch of ways to say that particular Latin phrase. I don't think anybody knows exactly how it's supposed to be said, because every circuit says it different, every state says it different. So, this might be one of those, just the response and opposition might just be a regional thing. Anyway, thanks for watching. Have a great day.